4 cases, 2 brand new felonies, and a defendant already out on bond. That's the kind of courtroom math that makes judges hit pause. Today, Daryl Spencer shows up facing marijuana possession, evading arrest, and a felon in possession charge stacked on top of priors. The state is pushing for higher bonds. The judge now has to decide, accountability today, or one more shot at freedom.
All right, so you are Daryl Spencer?
Yes, ma'am.
And Mr. Spencer has 4 cases, 24 DCCR 1863 charged with possession of marijuana, 25 DCCR 1149 charged with evading arrest or detention with the use of a vehicle, 25 DCCR 1150 charged with unlawful possession of a firearm by a felon, and then 24 DCCR 0841 also charged with evading arrest or detention with the use of a vehicle. And the state has filed motions in those 2 newer cases, cause numbers 25 DCCR 1149 and 1150, to raise the bond in those, or increase the bond. It looks like the current bond in each of those cases is $15,000. The bonds on those 2 previous cases, one was $7,500 and one was $25,000. And Ms. Malfino, you may proceed.
Judge, based on the fact that Mr. Spencer was out on bond, bless you, and then committed at least 2 additional felony offenses, we would ask, just based on the totality of the circumstances, the nature of the offenses themselves, the court raise all of those bonds and place him back in custody. And I will provide discovery to Mr. Kimler on the 2 new cases. He indicates today that he's going to be hired on those, but
I have you on all of them, right?
Yeah, I'm on all of them.
Okay, I'll make sure.
If everyone will give me just a minute, I am going to take judicial notice of the court's files and all of the cases, which include the probable cause affidavit in those 2, well, all of them. Give me just a second to.
Just to be clear, the offense dates on the 2 new offenses are after the other 2 offenses, is that right?
Yeah, so the offense dates on the 2, we've got the possession of marijuana offense date of February 15th of 2024, and the evading arrest or detention from March 2nd of 2024. And then we've got 2 new cases, one from June 14th of 2025, the evading arrest or detention with the use of a vehicle, and then June 15th, the unlawful possession of a firearm by a felon of this year. So give me just a second to review all of this, and then I'll let you. Sorry, I should have had these done already. Got one more, I'm coming, I think. All right, so let's see. On the 2 older cases, it looks like bond was made May 24th of 2024. So he was definitely out on bond on those when the 2 new. I should have one more.
Additionally, Judge, he has been before this court before in 2017, as well as next door and in front.
So we've got, here's the,
We're gonna just go with the Class A amount. Yeah, it's gonna drag it. So this might be less than 750. Less than 750. Yeah, that should get us to what, Class A or B?
Yes, that's the one.
Let's do A, that's what we'll do.
Thanks, honey.
all right, so the unlawful possession of a firearm by felon and that evading, same offense, or date, pretty much same. And then okay, I should have another one. I should have one. Is there not anything else I printed?
Two of them are the same.
I know. I should have three. These two are the same, but I should have this one and another one. I
That's
thought
the three printed.
okay, hold on.
Yeah.
All right.
I think I filed them in both cases.
You did. I'm just trying to find the
It's the same
PCs
PC.
from the, I'm trying to look at the underlying PCs as well. So give me just a second to pull up the, which one is, what am I trying to
Well, it'd be
find?
the same, probably the same
There's
PC for
two
each
same
case.
Evading.
ones, two printed.
0841. I didn't just print this one?
And two of them look just the same, but there's still something in it.
Okay, maybe that's it. Why did it do two? What's happening? Okay. So you said he's previously been in other courts. What other, do you have convictions?
I do, Judge, I do have a conviction in this court from May of 2017, 9 months in state jail for engaging in organized criminal activity. Also, it appears that in 2017, he was also in drug court for third-degree possession. It looks like he received probation on that case. There was a knock on that, so I don't want to misrepresent that. He did get 3 years TDC on that, Judge, on revocation, and then in CDC back in 2023, he was given a lesser included Class A deadly conduct, where he served 1 year in jail.
Mr. Kimler?
Well, yeah, I'm not prepared to litigate the merits of the two new cases without compromising defense. I suppose the court will have to stand on the PCs. I know that he's employed, is that correct?
What's on the report, yes, sir.
Longshoreman, and is endeavoring to maintain a law-abiding lifestyle. I believe he could pass a drug test in lieu of an increased bond if the court is inclined to take some sort of remedial measures. Regarding Mr. Spencer's conduct while on bond for the previous 2 cases, I would suggest a GPS device in lieu of increased bond.
I don't see how a GPS is going to help when you're out on bond. You've got 2 felony convictions, a state jail and a TDC conviction. You're out on bond for a felony possession of marijuana and an evading arrest, and there's an additional arrest for an evading and an unlawful possession of a firearm by a felon. I'm going to, based on the criminal history, based on the nature of the underlying offenses, and all of the factors in 17.15, I am going to grant the state's motion to increase bond in cause numbers 251149 and 251150. I'm going to raise the bond in each of those cases to $100,000. Condition of those bonds, if made, are that Mr. Spencer not be allowed to drive a vehicle, period, on bond, and that he wear a, I'm not worried about that necessarily. Obviously can't have a firearm, but no driving whatsoever. All right, you can go back with the bailiff, and I'll reset the case for an announcement, or the cases.
This next case shifts from danger on the streets to danger inside the home. A plea deal reduces a serious charge to attempted child endangerment, with deferred probation offered. But the judge isn't just signing off. Mental health supervision and a PSI are now the battlefield as the court weighs parental rights against proven risk.
This is Mr. Coleman on Roland Guillory. Good morning, you're Roland Guillory? All right, this is 24 DCCR 1568, and
So we have an agreement except for one aspect that we
Okay.
wanted to ask the court about.
okay,
So the agreement is to plead him to a lesser included attempted endangering a child, misdemeanor, Class A misdemeanor, 2-year deferred probation, $500 fine, forfeit the weapon. He wants him to have psych evaluation because he does have he has a diagnosis of bipolar. But then there was also no contact with the mother of his child and supervised visits with the child. So the case stems from his mother, meaning the child's grandmother, calling, stating that he made a statement saying he was going to harm himself and the child. So his mother calls the police. It is documented his mother was intoxicated at the time that she called the police, but so the police stop his vehicle. He lets them know he is licensed to carry. He had his gun in his holster. It was no belligerent scene, and so they removed the golden holster and took him into custody. It was, and so
just based on that, I think what I would like to do, a couple things. One, even though it's being pled down to a misdemeanor, get a PSI, which will
Okay.
give me more information, that it can also have time to get the psychological evaluation done.
Okay.
And during that time, have supervised visits. And then all that may change, but I think to be on the safe side, just pending sentencing,
Okay.
have no unsupervised time with the child. Are they still together?
No, this happened last year. So they co-parent. I talked to her last week. So she said she didn't want the no contact. So that was our issue. Because I talked to her and she was like, she doesn't agree with that because they co-parent well and she's in school. So he has the child while she's in school. But Mr. Coleman said he talked to her in June. And so she did tell me, she said, well, at the time they weren't on very good terms. So she might have told Mr. Coleman she didn't want. But now she said they are on good terms. And so that was our issue, you know.
I've got notes in my file contradictory. I'm not doubting what
She
Ms.
said,
Holmes'
yeah.
version is today, as we stand here today, but I have a different version based on my conversation back in August of 24.
Oh, that's a whole year
with the
ago.
complainant.
Okay, so the
And
August
she's
of
not the
24.
complainant. She had nothing to do with
She's
this.
not.
Well, mother of the child.
Yeah. So she had nothing to do, like she wasn't on the scene,
Well,
she wasn't.
Is she
Since
here?
we're doing
by
a lot
No,
of
chance?
she's
this-
not.
Since we're talking a lot about extraneous things, Judge, and what other people said and say, she did tell me back in August of 24 that the defendant has a history of being harassing and threatening with regard to her. So,
But you haven't heard anything since then?
no, ma'am.
And that was a year ago?
Yes, ma'am.
Can I say one thing, Judge?
Yeah.
I do get my son every other weekend since this incident has happened, so, and we haven't had any issues. I talk to my baby mother every day. My son actually started school this year, so that's.
But y'all aren't still in, you and the mom aren't in a
we're not
relationship?
together. We're more of like friends. We decided we couldn't be together.
I mean, the fact that it's been a year and they've been doing that, I feel like that's probably okay. So let's, but I do think even though, let's do a PSI though, but I'll allow things to continue as they have been. And then, have you been receiving any treatment for any diagnosis
I
that
did
you?
go to spinal tap, and I did get prescribed some medicine. I got prescribed some sleeping medicine, some bipolar medicine, and antidepressant medication.
And are you taking all that
No,
regularly?
ma'am, not currently.
Well, that causes me concern. So,
I haven't been on it in more than 6 months.
why?
I'm having transportation issues getting back to spinal tap.
Okay. How do you get your child? And
My baby mother will drop him off to my house.
okay, you're gonna have to go to. You're gonna because of the nature of what you're saying that happened, and even though if she was under the influence, if there was some threats that had to do with that and some mental health issues, then at least and we can do as quick turnaround as possible on a PSI. I am going to have only supervised visits between now and then. You need to get back to spinal tap when you come back for sentencing. You need to show me that you are cooperating and doing everything and following any treatment that they say, because it's going to be a part of your probation now. So you need to figure out a way to get there. You need to figure out, they'll help you with medication, whatever it is. And I want to know what you're on, what you're taking, and that you are following through with everything so that I know that you are in a good place, so that your child's in a good place, because we don't need to go back to what happened. So for now, you're going to be supervised only. So if you have someone that can supervise, great. If not, you just might have a couple of weekends that you go without, but we'll do it as quickly as possible. So let's go ahead and go through the plea then.
Yeah, 'cause your mom.
Do y'all didn't do paperwork already
I
though?
have it here.
Okay, yeah, I'll hold it while y'all get that
So
done.
what do
I'll
you want me
recall
to-
it.
Because I didn't put as far as the agreed recommendation, him having no contact with his.
You don't
child
have to put it
anymore.
as an agreed recommendation. I'll order it.
No
if you-
contact?
Judge, what I intended with the states, I recognize for the purposes of child exchange, there has to be some type of working.
Oh yeah, I'm not worried about the contact with her. That doesn't seem to be an issue. It doesn't sound like that was an issue in the underlying part. So I'm not going to order no contact with her. I'm going to order supervise with the child, because it
Okay.
sounds like is what the underlying offense had to do with, not her.
Okay.
So y'all can either agree to mark it off, or I'll do it when it comes through. If you want to argue for it, that's fine, Mr. Coleman. But no, I'll allow him to have contact. You can have phone conversations with your child. You can FaceTime between now and then. I just don't want if there's a supervised, y'all could if you can go somewhere, go to McDonald's, meet her there, have breakfast or lunch or something. No unsupervised. So I'm not saying you can't see them, but you just have to have somebody appropriate supervising until I get some more information. Does that make sense?
Yes, ma'am, it does.
Okay, and it can be her. If y'all are getting along, it sounds like that's not an issue. But I would say it's not going to be at her house. I want y'all to be somewhere public. That's not a good idea. Okay.
Today's docket put two very different issues under the same spotlight: public safety versus second chances. Case 1 involved a defendant with prior convictions, already on bond for marijuana and evading charges, who then picked up 2 more cases, evading in a vehicle and unlawful firearm possession, just weeks later. That timeline mattered. The court confirmed he was out on bond since May 24, 2024, when new arrests dropped on June 20th. Reoffending on bond is exactly what triggers stricter review. Prosecutors asked to raise bonds, citing history, seriousness, and community safety. The defense floated GPS monitoring as an alternative, but the judge didn't buy it. If the issue is repeat crimes while free, a tracker won't fix that. The ruling: bonds raised to $100,000 each on the new charges, with strict conditions: no driving, no firearms. Case 2 had a different tone, but the stakes stayed high. A plea to attempted child endangerment, a misdemeanor, came with deferred probation, a fine, and a gun forfeiture. But the judge refused to treat this like routine paperwork. With a bipolar diagnosis, gaps in treatment, and conflicting reports, the court ordered a PSI and supervised child visits until sentencing. Key point: contact with a co-parent was fine, but unsupervised time with the child was off the table. The message was sharp: rehabilitation is possible, but only with compliance, treatment, and safeguards. Taken together, the outcomes drew a clear line: mercy exists, but only when risk is under control. In Case 1, repeat crimes on bond meant a hard reset. In Case 2, the court protected the child while allowing co-parenting, backed by supervision and proof of treatment. What's your take? Was the $100,000 bond the right call? Should GPS monitoring ever replace higher bonds when reoffending is alleged? And in custody cases, how much weight should mental health treatment carry in parenting decisions? If these cases shocked you like they did us, hit that like button, drop a comment, and subscribe for more eye-opening courtroom breakdowns.